hours.
Yes, sir.
Can I talk to you for a minute?
Talk to me right here.
I understand that you own one of these as well.
No, it's not one of them.
Right?
No, it's not one of them. Talk to me.
Huh?
Talk to me. I'm listening.
I'm asking you. You own one of these, but not this one.
I own
right?
all of them. Yes.
So they have a trespassing affidavit.
I own this one too.
Okay. He's saying you don't.
I don't. I know what he's saying. I bought this store.
Okay.
I bought this
so
store.
How come you're not allowed to your own store if you bought it?
I don't know what you're talking about. I'm not allowed.
I've never seen it because you locked it up.
What?
The actual owner, you saw him walking in there.
I'm the actual owner.
He's got the affidavit already signed off for trespassing.
What affidavit?
The affidavit that they showed me. And I'll show it to you gladly. But if they're asking you to leave,
I'm not leaving.
To leave?
You can show me the affidavit.
Okay, put your hands on your back.
No, show me the affidavit. What for?
Easy. Trespassing. Easy. Stand up for me.
Man,
Easy.
can I?
You resist, it's another charge.
No, bro, I'm not resisting. I'm not resisting, bro. I'm not resisting.
Something you resist, I'm stacking another charge.
I'm not resisting, bro.
You pulling your arm away from me?
No, I'm not resisting, bro. I can't believe you're doing this, dog.
Relax. Hands back.
Bro, come on, dog. I can't believe you're doing this shit, dog. Bro, come on, man. I ain't do nothing, dog. Why you doing this, bro? Why you doing this, bro? I ain't do nothing. Bro, this is not right, dog.
I got suspect resisting.
That's not right, dog.
Hands behind your
back. No, man, get off me, man. Get off me, man.
Behind.
No, I ain't doing nothing, dog.
You're under arrest.
No, I'm not.
Trespassing.
You ain't even show me the affidavit.
I ain't gonna show you nothing.
Yeah, you do.
Now. Get your hands behind your back.
Nah, man.
You're already taking another charge. You want your taste?
No, I ain't do nothing.
Taste?
What you gonna tase me for?
Feel that? You got about 3 seconds to apply, or I'm about to take
What you gonna tase me for, bro? Ah! Bro, what you gonna tase? I ain't do nothing, bro. Nah, bro.
Turn around. Put your hands behind your back. Put your hands behind your back. Now, behind your back.
April 13th, 2026, Houston, Texas. A Monday afternoon, a man is standing outside a business he built from nothing. He has his phone out. He is live streaming not because he expected anything dramatic to happen, but because he wanted witnesses. What happened next is now one of the most watched videos on the internet this week. And once you understand the full story behind it, you will understand exactly why. This channel exists because stories like this one deserve more than a 30-second clip in a comment section. If you are new here, subscribe right now because we do not let these stories disappear. Hit the bell, share this video before you finish watching it. Someone in your circle needs to see this today. Now, let's get into it. Marcus Bowser did not grow up with advantages. He grew up off Martin Luther King Boulevard in Houston, Texas, which tells you everything you need to know about the environment he was navigating from the jump. No generational wealth, no safety net, no connections opening doors. What he had was a co-founder named Warren Broadnax, a fellow Houston native he met while both of them were serving in the United States Navy. Two young black men from the same city, the same struggle, the same hunger to build something that was actually theirs. In 2012, they pooled every dollar they had between them, $900, and started selling hair extensions out of the trunks of their cars. That is not a metaphor. That is literally what happened. Two veterans, two car trunks, $900, and a gap in the market they saw clearly. Black women in Houston were being underserved by an industry that either ignored them or overcharged them for quality hair products. Bowser and Broadnax moved into that gap and never looked back. The company they built is called She's Happy Hair. Today, it has 5 locations across Texas, 3 in Houston, 1 in Dallas, 1 in Arlington. Over 220,000 followers on Facebook, over 235,000 on Instagram, the company calls itself the #1 virgin hair supplier in the United States. Revenue by multiple independent accounts has crossed $100 million. $100 million built from 900. That is the American dream. That is exactly the story this country tells black people they are supposed to chase. Work hard, serve your country, build something real, and you will be rewarded. Marcus Bowser did all of it. And on April 13th, 2026, he ended up in handcuffs in the back of a police car outside his own store for over an hour. When the video first hit social media, the 30-second version was everywhere. A black man, a cop, a taser, a business he co-founded. That is enough to make anyone's blood run cold, and it should. But this story has layers that the clip does not show. And those layers matter because they make what happened not less outrageous, but more specific. And specific is what leads to accountability. So let's go all the way back. In November 2024, Warren Broadnax Bowser's co-founder, his Navy colleague, The man who started this thing with him when they both had $900 in a dream filed a lawsuit against Bowser. The complaint, later amended in February 2026, contains serious allegations. It claims that Bowser transferred $90,000 from company accounts into his personal bank account over 5 days in October 2024. It accuses him of using company credit cards for personal expenses, of aggressive behavior toward employees, and of forcing store closures that cost the business revenue. The complaint states directly that those withdrawals left the company unable to order inventory, maintain operations, or meet payroll. Those are not small accusations. They describe someone actively dismantling a company from the inside. Bowser denies all of it. He responded with a countersuit earlier in 2026, accusing Broadnax of the exact same category of behavior improper expenditures, restricting access to company meetings and financial data, and hiring family members through what the filing calls extreme nepotism. So now you have two co-founders, both accusing each other of stealing from the company they built together. And the employees? Their sworn statements cut directly down the middle. One affidavit from January accuses Bowser of intimidating workers and calls Broadnax a stabilizing presence. Another affidavit, signed by the mother of a different employee, claims Broadnax instructed staff to exaggerate or fabricate incidents involving Bowser entirely. Two sworn statements, opposite stories, both under oath. This is the context. A company worth $100 million being torn apart from the inside by the two men who built it together from $900. And this civil war had been playing out in Harris County courtrooms for months before a single police officer showed up. In December 2025, a judge granted a temporary restraining order against Bowser. Multiple reports confirmed that this order barred him from entering the company's business locations and that it was one of several such orders issued since the lawsuit was filed. Courts have been intervening in this dispute repeatedly, and repeatedly on Broadnax's side. Here is the critical detail. Under Texas law, temporary restraining orders generally expire after 14 days. The December order expired in January 2026. As of the day of the incident, April 13th, there is no publicly available record of an active, current court order barring Marcus Bowser from that specific location. That matters enormously, because what happened on April 13th turned entirely on the question of whether Bowser had a legal right to be there. And based on the public record, he did. April 13th. Bowser shows up at one of the Houston locations. Employees block him from entering. He does not force his way in. He does not escalate physically. He does what a person who believes they are being wronged is supposed to do. He calls the police. He wants help getting into his own store. He starts live streaming because he wants the world to see exactly what is happening. A Houston police officer arrives. What follows is visible in the footage. The officer tells Bowser he has seen an affidavit stating Bowser is no longer the owner of the business. Bowser, who is still listed as co-owner in court documents and tax records at that very moment, pushes back. He says that is not accurate. He says he purchased this store. He says he co-owns this company. Then Bowser asks to see the affidavit. That is a reasonable request. That is the only reasonable request. If someone is about to remove you from a property based on a document, you have an obvious and legitimate interest in seeing that document. Any attorney in the country will tell you that. Any person with basic common sense will tell you that. The officer does not show the affidavit. The officer tells Bowser to put his hands behind his back. Bowser asks what he is being charged with. The officer says, on camera, that he is stacking charges. Those two words, stacking charges, are not de-escalation language. They are a threat. They tell a person that asking questions will cost them. They are designed to produce fear and compliance, not clarity and resolution. What Bowser had done at the exact moment those words were used was ask a legal question while standing still. The taser fires. Marcus Bowser, Navy veteran, college graduate, co-founder of a $100 million company, is handcuffed and placed in the back of a patrol car. He sits there for over an hour. When he requests a supervisor, a sergeant arrives. By Bowser's own account, the sergeant actually listened to both sides. The sergeant did not tase anyone. The sergeant de-escalated, which proves something important. What the first officer did was a choice. It was not the only option available to him in that moment. Another officer, arriving at the exact same scene, made a completely different choice. That contrast is not incidental. That contrast is the whole point. Here is the detail that should be making national news and isn't getting nearly enough attention. As of right now, the affidavit the officer claimed to have seen has not been produced. Not to Bowser, not to his legal team, not to the media. It does not appear in Harris County court records. For a trespass enforcement to be valid in Texas, there needs to be a trespass affidavit, a written, signed document filed with law enforcement that authorizes police to remove a specific person from a specific property. Without that document, the entire legal foundation for the trespass arrest is questionable from the first step. No active court order, no producible affidavit, a co-owner on record in court documents and tax filings, and a taser. The Houston Police Department has not publicly commented on the incident. No charges against Bowser have been announced. No charges against the officer have been filed. The case is still entirely in limbo as of this video. The controlling legal standard for police use of force comes from Graham versus Connor, a 1989 Supreme Court case. Courts examining use of force claims look at three things: the severity of the crime, whether the suspect posed an immediate physical threat, and whether the suspect was actively resisting or fleeing. Walk that standard against what was on that sidewalk. The alleged offense was trespassing a Class B misdemeanor in Texas. That sits at the lower end of the severity scale. There is no video evidence of Bowser posing a physical threat to anyone. He was standing. He was talking, he was asking questions, he was not running, he was not raising his hands, he was not moving toward the officer aggressively. He was asking what he was being charged with. Asking that question, clearly and firmly, while standing still, is not under any legal standard that exists in this country justification for deploying a taser. If Bowser pursues a civil rights claim under Section 1983 of the Federal Code, the officer will almost certainly raise qualified immunity as a defense. That doctrine protects officers from personal civil liability unless the constitutional violation was clearly established at the time of the incident. Whether the specific facts here, a co-owner, no valid court order on record, asking a question before being tased, clear that bar is ultimately what a court would have to decide. But the factual foundation for a serious lawsuit is right there in the video, every second of it. Now, here is the part of the story that is uncomfortable to say out loud, and this channel does not skip the uncomfortable parts. Marcus Bowser called the police. He called them for help. He dialed 911 in the middle of a business dispute because he believed he had a right to be in that building, and he wanted someone with authority to help him exercise that right. That was a reasonable thing to believe. Based on the public record, his legal position appears to have been correct. He had every right to make that call. And what happened when the police arrived is now a viral video of a black man being tased outside a business he co-founded. That is not an argument against calling for help. People have every right to call for help. But it is a documented, recorded, live-streamed reminder of the gap that still exists in this country between what that call is supposed to produce and what it actually produces, depending on who is answering and who is standing on that sidewalk. A business dispute between two private parties over ownership and access is not a criminal matter. It is a civil matter. It was already in a courtroom. It had been in a courtroom for months. Judges had been issuing orders. Depositions had been taken. A trial was months away. An officer arriving with a taser and a decision already made does not resolve a civil dispute. It sets it on fire. And it does something else, too. It reminds every black business owner in this country, every black entrepreneur who did everything the script said to do, that the distance between success and a patrol car can be exactly one misunderstood phone call. In an interview after the incident, Bowser said, "I feel I was wrongfully tased. I'm glad it was live streamed. And I'm blessed he didn't pull his gun, that it was just the taser this time." This time, 2 words. Read them slowly. He also wrote this in his Instagram caption. Imagine growing up off Martin Luther King, joining the military, graduating college with a business degree, building a brand from the ground up, going from $800 to 9 figures in sales, creating jobs and opportunities across the country, only to face internal disputes and escalation beyond the boardroom. That is not bitterness. That is exhaustion. And it is the specific, particular exhaustion of a black man in America who played by every rule, built something extraordinary, and still ended up in handcuffs outside his own store while his country watched on a live stream. The civil lawsuit between Bowser and Broadnax is unresolved. Both men were deposed on April 8th. A trial is likely several months away. The affidavit the officer referenced has not been produced publicly. HPD has not commented. No charges have been filed against anyone. The story is not over, not by a long way. This channel will stay on it. When HPD responds, if they respond, you will hear it here. When the civil case produces a new filing, you will hear it here. When that affidavit surfaces, or is confirmed not to exist, you will hear it here. Marcus Bowser built a company worth $100 million. He served his country. He did everything this society tells black men to do to prove they belong. And on April 13th, 2026, he sat in the back of a police car for over an hour outside his own store because someone he called for help arrived and decided a taser was the answer. That is where we are. If this video found you, share it before you leave. Subscribe if you are not already here, and drop your thoughts in the comments because this conversation is not finished. The cameras will try to move on. We don't move on. See you in the next one.
Get off me, man.
Behind.
No, I ain't doing nothing, dog.
You're under arrest.
No, I'm not.
Trespassing.
You ain't even show me the affidavit.
I ain't gonna show you nothing.
Yeah, you
right
do.
now. Get your hands behind your
Nah,
back.
man.
You're already taking enough charge. You want your case?
No, I ain't do
Want
nothing.
your case?
What you gonna tase me for?
Feel that? You got about 3 seconds to comply, or I'm about to take
What you gonna tase me for, bro? Ah! Bro, what you gonna tase? I ain't do nothing, bro.
Hey,
Nah, bro.
Turn around. Put your hands behind your back. Put your hands behind your back. Now. Behind your back.
Hey, don't grab her like that, homie.
You can't jump this.
Don't grab her like that, dog.
Yes, but listen.
Hey, bitch ass nigga. Hey, let me get your badge number. Let me get your badge number. What the fuck that gonna do, nigga?
On the 21st of May, 2025, a San Bernardino police officer arrived at a grocery store parking lot, walked up behind a 17-year-old girl without a single word of warning, grabbed her by her backpack, pinned her arms behind her back, partially handcuffed her so she could not protect herself, and then flipped her body into the air and slammed her face first into the concrete. She weighed 90 pounds. She lost consciousness before she even hit the ground. She woke up on the freeway in a police car, blood soaking through her shirt, her chin split open and still bleeding, her wrist dislocated, her brain traumatized, her memory fractured, permanent scars on her face, 8 stitches under her chin, a traumatic brain injury she is still living with today. She was days away from walking across a stage to collect her high school diploma, and the officer, when she asked him what happened to her, he looked her in the eye and said, "You fell." If this is your first time here, this channel exists because stories like this one cannot be allowed to disappear. Hit subscribe right now. Every single subscriber tells the algorithm this story matters. Like this video and tell me where you are watching from. A high school senior in San Bernardino, California, with graduation literally days away. This is not a person anyone with a functioning conscience looks at and sees a threat. This is a child. A child who went to a grocery store after school and never came home the same. Now, before a single police officer even pulled into that parking lot, Aaron had already been through something that day. Inside the Food 4 Less on West 2nd Street, a group of teenagers had been bullying and assaulting other young people. It got bad enough that a security guard had to deploy pepper spray inside the store to stop the attacks. And Aaron was one of the people those teenagers attacked. She was a victim. Before any of this happened, before any officer laid a hand on her, she had already been assaulted by someone else in that building. So what did she do after being attacked? She did what any teenager would do. She walked outside to find her friends. That is it. That is the full extent of what she did. She crossed a parking lot toward people she knew who were standing outside. Not fighting, not running, just standing. And witnesses saw the whole thing. When officers arrived, those witnesses told them directly Aaron was attacked. Aaron did nothing wrong. Aaron is not the aggressor here. Let that sit for a second, because it matters enormously for what comes next. Officers Jackson Tubbs and Cynthia Guillen responded to the scene, both wearing body cameras. And a witness in that parking lot was also recording on a cell phone. So we have 3 cameras, 3 angles, rolling simultaneously. Everything that happened next is on tape. Officer Tubbs spotted Aaron walking across the parking lot toward her friends. He did not call out to her. He did not identify himself. He did not issue a single verbal command. He gave her no instruction to stop, no instruction to identify herself, nothing. He walked up behind her and grabbed her by her backpack. Aaron, 90 pounds, was jerked off balance immediately. She felt the pull on her backpack and did what any person would instinctively do. She reached to remove it. That is it. That is what happened. She reached for her own backpack, and Tubbs responded by pinning both of her arms behind her back and placing her in handcuffs. One cuff on her wrist, the second never made it on. So now she is partially restrained. Arms pinned, one wrist cuffed, hands completely unable to move freely, unable to catch herself, unable to brace for anything. And then Officer Tubbs performed a hip toss. He launched a 90-pound 17-year-old girl into the air. Her legs flew over her head, and she came down face first, head first, onto asphalt, onto concrete. She had no free hands. She could not protect her face. She could not break her fall. There was nothing between her skull and that ground. She lost consciousness on impact. The last thing she heard before everything went black was Officer Tubbs telling her to stop resisting. Stop resisting. She was unconscious before she even finished falling. Blood poured immediately from a gash beneath her chin. Her friends, visible in the witness video, are screaming. Erin Kauser did not get up. She was out cold on the pavement outside a grocery store on a Wednesday afternoon at 2 o'clock in the afternoon. Now, I need you to understand something. Before Officer Tubbs grabbed her, Erin had no blood on her face, no injuries. She was walking upright. The body camera footage from Officer Guillen confirms this. The cell phone video confirms this. The sequence is not in dispute. It is on camera. She regained consciousness on the freeway, moving fast. Somewhere she did not recognize. She looked down and saw blood on her shirt, on her body, her chin still actively leaking. She looked up and found the officer. He had her phone in his hand. She asked him, "What happened to me? What did you do to me?" He said, "You fell," and then she blacked out again. She woke up in a hospital bed, traumatic brain injury, 8 stitches beneath her chin, permanent scarring on her face, dislocated wrist, back injuries, memory loss she continues to experience today. Now, here is where this case goes from being a use of force incident to something far more deliberate. Because according to the lawsuit filed in San Bernardino County Superior Court, Officer Tubbs did not say, "You fell once and stop there." That was just the beginning. When Erin's grandmother arrived, Tubbs told her the injuries came from the fight inside the store, not from the takedown, from the other teenagers. He told Erin's aunt the same story. He told Erin's mother, Tanya Brownridge, the same story in a phone call made from the patrol car while they were en route to the hospital. That call is captured on body cam. He described his daughter's condition as and I want you to hear this, a little cut from the fight on her face. Officer Guillen was in that car. She heard every word. She said nothing to correct it. And then, according to court documents, that same false account was repeated to the doctor treating Erin at the hospital. 5 separate people, 5 separate occasions, the same lie, told while body camera footage existed that demolished every single word of it. Attorney Tony Jaramillo said it plainly at the April 2026 press conference, and I am going to paraphrase her words from the public record. This was not a mistake. It was violence, followed by deliberate dishonesty. An officer took a petite, unarmed teenage girl with her hands behind her back and hip-tossed her face first onto concrete. Then he lied about it. And when the truth came out, the department still refused to correct the record. Let me say that again. According to the lawsuit, even after an officer admitted during a formal use of force review that false information had been provided, the San Bernardino Police Department issued no public correction, no statement, no retraction, nothing. Now I want to talk about something that does not get discussed enough when cases like this surface. Officer Jackson Tubbs was not a first-time subject of concern. In 2023, Tubbs was involved in a separate incident. That prior matter resulted in the city of San Bernardino agreeing to a settlement of nearly $4,900,000 finalized in 2025, the same year he flipped Erin Kauser into concrete. Nearly $5 million. That is the price tag San Bernardino taxpayers paid for a prior incident involving this same officer. And he was still on the streets, still in uniform, still responding to calls. So when Erin's father, a military veteran who served this country for 15 years, stood at a microphone outside the San Bernardino Police Department and said he did not appreciate a male officer handling his 17-year-old daughter the way she was handled, and called it a direct violation of her human rights, understand that he is not speaking in a vacuum. He served 15 years for this country. 15 years. And he came home to watch body cam footage of his daughter being slammed into concrete and lied to about it. He said, and these are his words from the public record, "This needs to stop. There is nothing I can add to that." Let me give you the current facts as they stand. The civil lawsuit was filed in San Bernardino County Superior Court in April 2026. It names Officer Tubbs, Officer Guillen, and the City of San Bernardino as defendants. The claims include excessive force, assault, battery, negligence, and civil rights violations under California's Bain Civil Rights Act and the Ralph Civil Rights Act. Body cam footage and witness video are cited as central evidence. All misdemeanor charges against Aaron Trespassing, allegedly attempting to fight, were dropped. Every single one. The city and the department have declined all comment, citing pending litigation. As of today, no verdict has been entered. No settlement has been announced. The case is in the courts. And Erin Kauser is 18 years old now. She says she has headaches almost every day. She says she is not the same person she was before May 21st, 2025. At the press conference, she said, "I just want somebody to be responsible for what happened to me, because I didn't do anything wrong." 2 cameras and 1 cell phone were rolling that afternoon. They captured a girl walking across a parking lot. They captured what happened to her. They captured what was said afterward. Here is what I need you to sit with. Erin Kauser went to a grocery store after school. She was attacked by other teenagers inside that store, making her a victim before a single officer arrived. She walked outside. She was given no commands, no warnings, no instructions. An officer grabbed her from behind, partially handcuffed her so she could not protect herself, and threw her face first into the ground. Then he lied about it, to her face, to her family, to her doctor, multiple times, on camera. She graduated high school days later in bandages. She is 18 with daily headaches and a permanently scarred face and a brain that does not work the way it did before that Wednesday afternoon. And the department that employed the officer who did this to her has still not corrected the record publicly. This is why this channel exists. Because Erin's story deserves to be seen. Because accountability requires witnesses. Because silence is how these stories disappear. If this video reached you, share it. Right now. Send it to somebody. Post it. The more eyes on this case, the harder it becomes to ignore. Subscribe if you are not already here. We cover these stories because they matter, because Black lives matter, and because the pattern does not end until enough people refuse to look away. We will be watching this case. When there are developments, we will bring them to you. Erin Kauser said she just wants somebody to be responsible. So do we.
Man, we got a call. You match the shoplifter description exactly.
Officer, I am a sheriff deputy. Badge number 2719. My ID is right here in the car. I can verify
You've
right
heard that
now.
one before. Step out right now and keep your hands where I can see them.
I'm complying. I'm not resisting.
The grocery store parking lot sat under the Texas sun at 3:42 on a Saturday afternoon. Sarah Jordan had just loaded the last bag into her vehicle after a normal weekly shop with her 10-year-old son. She still wore a simple blue blouse and black leggings. Her son's favorite Houston Astros cap rested on the dashboard. Their body cameras were already rolling, recording what would become the most expensive grocery run in Texas history. If you are ready to see institutional racism taken down, like this video and drop a comment telling me where you're watching from. And if this is your first time here, hit that subscribe button right now because you won't want to miss tomorrow's story of cops messing with the wrong people and finding out. Let me know if you enjoyed the story. Let's continue. 2 white male officers approached her vehicle in formation. Sarah watched them in the side mirror. 15 years as a sheriff deputy had trained her to read spacing, hand positions, and intent in seconds. They moved toward her like the decision had already been made. Her son sat in the passenger seat, still talking about a snack he wanted to open. He stopped mid-sentence when the officers reached the driver's window. The lead officer spoke first. "We received a call about a shoplifter. You match the description. We need to see identification and proof you are not involved." Sarah kept both hands on the steering wheel where they could see them. "I am a sheriff deputy. Badge number 2719. My department identification is in my wallet in the center console. I can call my precinct right now to verify everything." The officer did not move. "We will verify once we have established who you are. Step out of the vehicle." Sarah felt the shift in the air. The second officer had moved to the passenger side and stared directly at her son through the window. Shoppers nearby began to slow down. A few phones came out. She opened the door slowly, hands raised. "I am complying. I am not resisting. There is no reasonable suspicion for this stop." The moment her feet touched the pavement, the first officer grabbed her wrist and twisted her arm behind her back. The second moved in. The handcuffs closed around her wrists with a sharp metallic click. Her son's voice cracked from inside the car. "Mommy!" Sarah kept her tone steady. "It is okay. Stay in the car. Do not move." The officers walked her toward the patrol car while more shoppers recorded the scene. Groceries sat forgotten in the open trunk. The hot asphalt radiated heat through her shoes. Her son's face pressed against the glass, eyes wide with confusion and fear. They placed her in the back of the patrol car. The door slammed shut. Through the rear window, she watched her vehicle and her son grow smaller as the patrol car pulled away. The officers refused every offer Sarah made during the short ride. They would not let her retrieve her wallet. They ignored her repeated statements that a single phone call to the sheriff's department would clear everything. The patrol car boxed her in at the scene before they even moved her. At 3:42 in the afternoon, the Texas sun still beat down on the parking lot. The smell of warm pavement and fresh groceries hung in the air. Sarah maintained a calm, even voice. She announced her badge number 2719 again and stated clearly that there was no reasonable suspicion or probable cause for the detention. The officers did not respond with verification. Instead, they secured her in the back seat and left her 10-year-old son alone in her vehicle. More phones captured the moment from a distance. The public spectacle grew as bystanders gathered. Sarah sat upright, hands cuffed behind her, and focused on controlling her breathing. Her son's terrified face stayed burned in her mind. This was supposed to be an ordinary Saturday errand. Now it had become something else entirely. As the patrol car moved through familiar streets, Sarah's thoughts turned inward. 15 years with the sheriff department had taught her how the system worked from the inside. She came from generations of Texas families who had learned early that belonging was something constantly questioned. She began to catalog every error she had witnessed in the last minutes. No reasonable suspicion, refusal to verify a clear claim of law enforcement identity, failure to provide proper warnings, and the decision to handcuff a compliant person in front of a minor child. She did not panic. Instead, she noted each violation with the precision of someone who understood the law from both sides of the badge. The anger burned steady in her chest, but it did not cloud her thinking. This was not the first time her appearance had caused someone to doubt her word. It was, however, the first time it had happened directly in front of her son. The patrol car continued toward the holding facility. Sarah sat in silence, already building the case in her mind. The holding facility smelled of industrial cleaner and stale air. Sarah was placed in a small beige-walled room with harsh fluorescent lights that hummed constantly overhead. For 3 hours and 51 minutes she sat on the hard bench, hands still cuffed behind her at first, then removed after initial processing. She spoke calmly to every officer who entered. She warned them about Fourth Amendment violations. She cited the lack of probable cause and referenced the standards set in Terry v. Ohio. The officers grew visibly uncertain as time passed. When they finally made the call to her sheriff's department and confirmed her identity and 15 years of service, the energy in the room shifted. A supervisor later entered and offered what he clearly considered an appropriate response. He described the entire incident as a mere inconvenience during a routine check. Sarah listened without expression. The casual dismissal only hardened her resolve. She demanded copies of all body camera footage, incident reports, and the names of every officer involved. The supervisor noted the request, but offered no immediate commitment. When they released her that afternoon, family had already collected her son from the parking lot after bystanders stepped in to help. Sarah drove home in silence. That evening, she held her son close on the couch while he finally fell asleep against her. The day's events replayed in her mind with sharp clarity. 15 years of community service had defined her adult life. Her family's Texas roots ran deep through generations who had faced similar questions about their place and their rights. She had earned a law degree from the University of Texas School of Law over 4 years of secret night classes and online courses while working full shifts and raising her son. She had kept the qualification hidden to avoid the professional backlash that often came with being a black woman seen as too ambitious in law enforcement. That hidden credential now felt like the one advantage the system had never accounted for. She decided the incident would not end with a quiet apology or an internal note. Sarah met with a civil rights attorney the following week. They filed a federal lawsuit against the city and the 2 officers involved. The claim centered on unlawful detention, racial profiling, and clear violations of her constitutional rights. During the discovery phase, the synchronized body camera footage and multiple bystander videos from the parking lot proved overwhelming. Every angle showed the same sequence: her calm identification, the repeated refusals to verify, the handcuffing in front of her child, and the lack of any documented reasonable suspicion. The city responded with 2 settlement offers. The first was $75,000. The second, after more evidence surfaced, rose to $350,000. Both came with strict, non-disclosure agreements that would bury the details and prevent any public precedent. Sarah rejected both offers. She insisted on taking the case to a full public trial so the facts could be heard in open court. Do you think officers should be required to verify a person's identity when they claim to be law enforcement before resorting to handcuffs and detention? Drop yes or no in the comments below and share this story if you believe accountability matters in situations like this. Trial preparation intensified in the months that followed. Sarah reviewed depositions and evidence late into the night. Her hidden legal expertise, kept quiet for years, now became her greatest weapon. The power dynamic had already begun to shift. though the full extent of that shift remained hidden from the other side. The trial opened in a packed Texas courthouse on a cold February morning. Off-duty officers and community members filled the gallery. Body camera footage and bystander videos played for the jury, showing the parking lot confrontation from multiple synchronized angles. The images left little room for interpretation. Sarah testified over 2 days. She described the fear she felt in the moment, the humiliation of being handcuffed in front of her son, and the lasting trauma that followed for both of them. The defense attempted to justify the stop by citing a vague shoplifter description received that afternoon. Cross-examination exposed the complete lack of documentation supporting that description and the procedural failures that followed. When defense attorneys began to explain basic constitutional principles to her on the stand in a condescending tone, Sarah interrupted calmly. She stated that she was familiar with the standards in Terry v. Ohio and other relevant precedents. She then revealed the credential she had kept private for years. She held a Juris Doctor from the University of Texas School of Law. She had earned it quietly over 4 years of night classes while continuing her duties as a sheriff deputy and raising her son. The courtroom fell silent. The power dynamic shifted in that single moment. Sarah continued with precision. She explained how she had mentally documented every violation in real time while detained. She cited case law that demonstrated the detention had exceeded any reasonable scope and lacked probable cause from the beginning. The jury deliberated for several days. When they returned, they found in Sarah's favor on all counts. In the damages phase, expert witnesses detailed the psychological effects on Sarah and her son. The jury awarded $11 million in compensatory and punitive damages. The courtroom erupted with reaction. Supporters stood. Off-duty officers remained seated in quiet solidarity. 6 months after the verdict, Sarah retired from the sheriff department. She kept her pension and her full service record. She used part of the $11 million award to establish a legal aid clinic that specialized in civil rights and wrongful detention cases. She funded youth sports programs and scholarships for single mothers in her community. She began mentoring young attorneys who wanted to use the law as a tool for accountability. One Saturday afternoon, Sarah drove past the same grocery store parking lot with her son, now a few years older. She did not stop. She simply noted the location where she had drawn a clear line that day. The trauma had not disappeared, but it had been transformed into steady, methodical action. She had proven that power underestimated could become power directed with purpose. One person's refusal to stay silent, backed by documented truth and preparation, could create ripples that reached far beyond a single courtroom and protected others who might face the same treatment. Justice, in the end, was not spectacle. It was method, endurance, and the quiet decision to act when the moment demanded it.
If you like this video, make sure to hit that like button, subscribe, and turn on the notification bell so you don't miss the next story. Share this video with someone who would appreciate it, and let's keep building this community together. And before you go, drop a comment below. I'd love to hear your thoughts on what stood out to you the most. Until next time, stay safe, stay curious, and I'll see you in the next.
What the heck? What did I do? What the actual heck? What did I do? I'm asking you, what did I do?
Take a moment. Just take a moment and watch that. A woman, hands already in the air, children in the car, multiple officers, guns drawn. And she's the one asking questions calmly, repeatedly, what did I do? And they can't answer her. Not because it's a complex situation, not because the answer is classified. They can't answer her because the honest answer would be, we don't actually know.
What the heck? Girl, you need to... I'm recording. What? Is this... We have a kid in the car. I have a baby in the car.
That's fine. Listen to me.
Put your gun down. What did I do? But what did I do?
I'm not arguing with you.
But why am I being stopped?
That right there, that 4-second exchange tells you everything you need to know about how this system operates when black people are involved.
Hands up and walk back here.
What the heck is going on? Like, what?
Like, what I need you to do is listen. But
her hands are up, though. What? Are they crazy? This is a joke. Oh my gosh.
Don't step out from me.
Oh my gosh. What the heck? I'm keeping my head. I'm staying recording, by the way. What the heck is going on? What? Baby in the car, by the way. What is going on? Okay. okay? Wait, hold on.
No, you good.
Wait, what happened? Attempted what? We just went.
Listen, where were you guys coming from?
Wait, we just came back from the house just now. Yes.
Where's your house at?
Denoso, like Polo Ranch. Polo Ranch. Okay. Wait.
Before we go any further, if you are new here, hit that subscribe button right now. We cover stories like this one daily. And drop a comment below, tell me where you are watching from. Here's what I want you to understand by the end of this video. What happened to Kathleen Booker on April 3rd, 2026 in Fulshear, Texas was not a mistake that exists in isolation. It was a predictable outcome of a policing culture that treats proximity to blackness as proximity to guilt. And the legal framework that is supposed to protect citizens from exactly this kind of encounter has been so systematically weakened that officers can do almost everything we saw in that video and face virtually no consequences. That is not an opinion. That is the architecture of the law as it currently stands. And we need to talk about it. So let's start with the facts, because facts matter. Especially when someone's going to come into the comments and say, we don't know the full story. We actually do. On the morning of Good Friday, April 3rd, 2026, Kathleen Booker, a Houston area realtor, a mother, left her home with her stepdaughter and her 2-year-old toddler in the car. Routine. Ordinary. The kind of morning millions of people have every single day. What happened next was anything but ordinary. The Fulshear Police Department was responding to a report of a gas station robbery on FM 1093. According to their own press release, the suspects were described as 2 black male individuals armed, wearing masks, who fled in a white Nissan vehicle. Officers spotted a white Nissan in the area. And that apparently was enough. They conducted what the department calls a high-risk felony stop. Multiple patrol SUVs, officers with weapons drawn, commands being shouted. Booker stepped out of her vehicle with her hands already raised, asking what she had done wrong. A female officer handcuffed her. Her stepdaughter was ordered out of the car. Officers then found Booker's toddler in the back seat. She was detained. She was searched. Her children watched all of it, and then once it became clear that none of this made any sense, she was released. No arrest, no charges. According to Booker, no apology at the scene either, though Fulshear PD disputes that. Let me be precise about what was wrong here. The suspects were male. Booker is a woman. The suspects were described as wearing masks. Booker was not. The vehicle type reportedly did not match. And Booker's own Instagram caption, which has since received nearly 500,000 likes, laid it out plainly. Different vehicle type, different race from the description given, different gender. And still, she was detained. Now, I want to be careful here because some people will hear this story and think, isolated incident, one bad department, unfortunate mistake, move on. But the data and the documented history will not allow us to do that. This is not the first time. This is not the 10th time. This is a pattern so established, so recurring, that journalists covering this story were able to immediately pull 3 comparable incidents from recent years without even trying hard. In 2021, a North Carolina woman pulled into her grandmother's driveway after a gym workout. Police surrounded the car and placed her under arrest for attempted murder. The reason? A misspelled name entered into a license plate reader system led them to the wrong person entirely. In 2023, a 12-year-old boy was detained while taking out the trash. Officers said his clothing matched a robbery suspect's description. It took his father coming outside to make police realize they had the wrong child. And just last year, an 11-year-old girl in upstate New York was arrested during a traffic stop, mistaken for a car thief. Cell phone video showed her crying as her friends tried to defend her during a police interrogation, 11 years old. When the same type of incident, wrong person, black person, high force response, minimal justification keeps repeating across different states, different departments, different years, at what point do we stop calling it a mistake and start calling it a feature? That is not a rhetorical question. I am genuinely asking, because the research on implicit bias in policing is extensive. Studies consistently find that black individuals are more likely to be stopped, more likely to have force used against them, and less likely to be given the benefit of the doubt during ambiguous encounters compared to white individuals in statistically similar circumstances. Kathleen Booker herself said it best. I have a clean record, and if this is what I experienced, I can only imagine what others go through every single day. That sentence should stop you cold, because she's not wrong. Now, I want to shift gears slightly, because I think this is where the conversation usually gets dropped, and it shouldn't. Let's talk about the law. Booker's attorney, Audia Jones, has stated publicly that her client's Fourth Amendment rights were violated. The Fourth Amendment to the United States Constitution protects citizens against unreasonable searches and seizures. It requires that any detention, any stop where you are not free to leave, be grounded in what the law calls reasonable suspicion at minimum and probable cause for an arrest. So the question becomes, did officers have reasonable suspicion to conduct a high-risk felony stop on Kathleen Booker? Here's where it gets complicated and where the legal system, as it currently functions, will not necessarily deliver the justice that common sense demands. Courts have historically given law enforcement enormous deference when it comes to Terry stops, that's the legal term for brief investigative detentions, stemming from the 1968 Supreme Court case Terry v. Ohio. Under Terry, officers can stop and briefly detain someone if they have reasonable, articulable suspicion that criminal activity is occurring. The standard is not probable cause. It is lower than that. Now, Fulshire PD's argument will essentially be, we received a robbery call, we observed a vehicle matching the general description near the area of the crime within a close time window, and we acted on that information. They will argue that those facts, taken together, gave them reasonable suspicion. And here is the uncomfortable truth. Depending on the judge, depending on the circuit, that argument might actually hold in court. This is not me defending what they did. I want to be very clear. This is me explaining why the legal path forward for Booker, as righteous as her cause is, will not be simple. There is also the issue of qualified immunity. Qualified immunity is a legal doctrine that shields government officials, including police officers, from civil liability unless they violated a clearly established law. In practice, what this means is that even if a court finds that officers violated Booker's constitutional rights, they may still be protected from personal liability if no prior case established with sufficient specificity that this exact type of conduct was unconstitutional. Critics of qualified immunity, and there are many across the political spectrum, argue that the doctrine creates a circular trap. Officers are immune unless there's a prior case, but prior cases are often dismissed because of immunity, so the clearly established bar is almost impossible to clear. It is, in the words of many legal scholars, a doctrine invented by the courts with no basis in the original text of the civil rights statutes it interprets. For Booker specifically, her strongest legal argument may lie in the clearly documented mismatch between the suspect description and her actual profile. 2 black males with masks, 1 black woman with children. If that gap is wide enough, and legally it arguably is, her attorney can make a compelling case that no reasonable officer acting in good faith could have identified Booker as a valid suspect. That is the wedge that could potentially pierce qualified immunity. She will also need the video. And, fortunately, critically, she has it. The footage recorded by her stepdaughter is one of the most important legal assets in this case. It contradicts the department's claim that weapons were never pointed at occupants. It documents the timeline. It captures Booker's compliance from the first moment she stepped out of that vehicle. In civil rights litigation, video evidence has repeatedly proven decisive. Not always sufficient, but decisive. Fulshire PD issued a formal statement, and I want to read part of it carefully, because the language they chose is revealing. They said, and I'm paraphrasing closely here, that officers made rapid decisions based on limited and evolving information, that the stop was based on a reasonable match to the suspect vehicle description, combined with the vehicle's proximity in time and location to the reported crime, and that their officers acted in good faith in accordance with training and department policy. Good faith in accordance with training. That last part is important. Because if this stop was consistent with their training and their policy, then the problem is not one officer having a bad day. The problem is systemic. The problem is institutional. And that actually strengthens the case for broader accountability, potentially including the department itself, not just individual officers. There is also something telling in what the department did not say. They did not say, we are reviewing our procedures to ensure this doesn't happen again. They did not say, we recognize the harm caused to this family. They defended the stop fully. And they noted that Booker's husband, who met with a supervisor, did not ultimately file a formal complaint, which, let's be honest, may have been the desired outcome. No complaint on record. No internal investigation triggered. Case quietly closed. Booker's decision to go public, to post the video, to speak to Isaiah Carey on Fox 26, that decision changed the calculus entirely. It forced a public response. It created a record. And it is precisely the kind of accountability that the formal complaint system by itself often fails to produce. I want to close with something broader, because this story is about Kathleen Booker, but it is also about every black person who has been in a car and felt that specific, particular fear when lights appear in the rearview mirror. It is about the mental math that black drivers do instinctively, automatically, that other drivers simply do not have to perform. Where are my hands? How do I sound? Will this officer decide that my presence alone is suspicious? Booker wrote on Instagram, "I'm tired of feeling alone in moments like this." She is not alone. And the fact that she chose to share as a self-described private person who normally keeps these experiences to herself tells you something about the weight of carrying this, about how exhausting it is to absorb these encounters in silence and simply continue on. The commentary around this story has also been revealing. Multiple black women who covered this story on television, on social media, immediately said some version of the same thing. I have been here. I know this feeling. This could have been me. That kind of immediate, widespread recognition is not coincidence. It is the lived experience of a community that has been navigating this reality for generations. And for viewers who have not personally experienced this, who are watching to understand rather than to recognize here, what I need you to take away. The danger in these situations is not hypothetical. It is not abstract. When officers approach with weapons drawn, based on a description that does not match, the margin for a fatal error is real. Booker complied. She kept her composure under extraordinary pressure, with her children watching, and she is here to tell this story. Not everyone has been that fortunate. Kathleen Booker has retained an attorney and is in the early stages of pursuing legal action against the Fulshear Police Department. That process will be long, it will be difficult, and the outcome is not guaranteed. But her willingness to go public to put her face and her story on record matters. Documentation matters. Video matters. Legal representation matters. And community attention, the kind that makes it impossible for departments to quietly close a file and move on, matters more than people realize. If you found value in this breakdown, share it. Not for the algorithm, though, that helps, but because someone in your circle may be navigating a situation exactly like this one and not know what rights they have, what recourse they have, or that they are not alone. We will keep watching this case. We will keep covering these stories, because the moment we stop paying attention is the moment they stop being accountable. Stay informed, stay grounded.
What? By the way. What is going on? Okay. Wait, hold on.
No, you good.
Wait, what happened? Attempted what? We just went.
Here we go. Where were you guys coming from?
Wait, we just came back from the house just now.
Yeah. Where's your house at?
Denoso, like Polo Ranch. Polo Ranch.
Oh, okay.
Okay. Wait.
Like that. I'm talking to you too. Generic.
On April 6th, 2026, in Osceola, Arkansas, a small city about 50 miles north of Memphis, Tennessee, a man was sitting in his wheelchair outside his apartment building, minding his business, worried about his family, when the person who was supposed to protect him walked up and slapped him across the face. That man's name is Denarius Williams.
That right there is why you're going to go to jail. You're not going to talk to me like that. I'm talking to you too.
He has been paralyzed from the stomach down since 2013 when he was shot in the back. He cannot feel or move anything below his belly button. He cannot stand. He cannot run. He cannot defend himself from the waist down. And the person who slapped him was not a stranger with a grudge. It was the chief of police. Before we go any further, if you are new here, this channel is where we talk about racism, power, and the consequences that follow when communities refuse to be silent. Hit that subscribe button right now and drop a comment below telling me where you are watching from. I want to know if you are tuning in from Atlanta, from London, from Lagos, wherever you are, tell me. Now let us get into it. The night of April 6th, 2026, police were called to the Hyatt Apartments in Osceola. The call was about teenagers fighting nearby. That is why officers showed up.
I already knew it was on.
already knew, baby. When that
That was the assignment. Denarius Williams was not part of that call. He was not fighting. He was not a suspect. He was a father and a husband sitting outside his home in his wheelchair, and what he found out when officers arrived was that his wife and his son had been handcuffed and detained. Now, ask yourself honestly, if that were your family, what would you do? You would want to know what was happening. You would want answers. That is all Denarius Williams wanted. During the response, the newly appointed chief of police, Robert Bobby Eflin, walked up to Williams. Words were exchanged. Williams, by his own account, told the chief to get his finger out of his face. He admitted he used some strong language. He said he told the chief to get his hands off him and to move his finger from his face. But he was clear. He did not touch the chief. He did not strike him. He fanned a hand away from his personal space. That is it. What happened next is on video. Eflin slapped Denarius Williams across the face. Then he reached around from behind and choked him. A paraplegic man in a wheelchair, who cannot move from the belly button down, was slapped and choked by the chief of police in front of his neighbors, in front of witnesses, with a camera pointed directly at him. Williams described it this way. He said he was smacked hard, and then choked. He said he felt helpless, belittled, embarrassed, and powerless. Think about what it means for a man who has already had his body taken from him once by violence, a gunshot that paralyzed him for life, to then sit in that same body and be struck by the highest-ranking law enforcement officer in his city, in front of his community, in front of his family, with nowhere to go and no way to defend himself. Here is the detail that makes this story even harder to sit with. Robert Bobby Eflin was sworn in as Chief of Police of Osceola, Arkansas on March 26, 2026. The incident at the Hyatt Apartments happened on April 6, 2026, 11 days. He had been Chief of Police for 11 days. 11 days into the job, this man handed authority over an entire community, given a badge, a title, and the public trust walked up to a wheelchair-bound paraplegic and put his hands on him. When the video went viral, Mayor Joe Harris came out and said he was shocked. He said, and I am paraphrasing here, that when he saw the footage, he could not believe it, because Bobby Eflin is not that kind of person. He said Eflin is at the school every week, working with kids. He suggested that Williams must have said or done something to provoke the chief. And I want to be careful here, because I want to be fair. I understand that a mayor who just hired someone does not want to believe the worst. But here is my problem with that framing. It does not matter what Denarius Williams said. It does not matter if he cursed. It does not matter if he was loud, emotional, or confrontational. His wife and child had just been detained by police. He was scared and frustrated. None of that, not a single word of it, justifies a police officer slapping a paralyzed man in a wheelchair and then choking him. There is no version of anger that makes that acceptable. There is no provocation that makes that defensible. And leaning on Eflin's reputation at the school does not erase what the camera captured. Now here's the part of the story that I do not want you to miss, because it reveals something important about how this night unfolded. Stephanie Williams, Denarius Williams' wife, was the one who called the police. She called them. She was trying to protect her family because something threatening was happening near their home. She reached out to law enforcement in good faith. She ended the night in handcuffs. Stephanie was arrested and charged with disorderly conduct and endangering the welfare of a minor. Her 15-year-old son was also arrested. She told reporters she had tried to intervene when she saw tensions rising. She said she tried to grab her son when she saw a school official with a gun pointed at him. She called the police. She ended up in jail. Her paralyzed husband was assaulted by the chief. Her teenage son was arrested, and the man responsible for all of it had been on the job for 11 days. That is not just excessive force. That is what the complete collapse of institutional trust looks like for a black family in a small American city. A woman trusted the system enough to call for help, and the system punished her for it. Now, let us talk about accountability, because feelings alone do not change anything. Structures do. Laws do. Charges do. Under Arkansas law, what Eflin did could meet the threshold for battery in the second degree. That applies when a person purposely causes physical injury to someone they know to be unable to resist. Denarius Williams cannot stand, cannot run, cannot raise a leg, cannot fight back from a seated position against a standing officer. A jury hearing those facts could reasonably conclude that Eflin knew exactly who he was dealing with when he struck him. Battery in the second degree is a Class D felony in Arkansas. That carries up to 6 years in prison. The choking is a separate legal matter. Any officer applying a chokehold to a civilian who has not been established as a physical threat faces an extremely difficult legal justification regardless of what words were exchanged. This was not a domestic situation. This was a uniformed police chief applying force to a member of the public during a call response. Under the Fourth Amendment, when a police officer uses physical force against a civilian, that constitutes a seizure under the law. The controlling legal standard comes from a Supreme Court case called Graham versus Connor, decided in 1989. Courts look at three things: the severity of the crime at issue, whether the person poses an immediate threat, and whether the person is actively resisting or trying to flee. Denarius Williams was not under arrest. He was not charged with anything. He was not threatening anyone. He was asking about his family. A man in a wheelchair who fanned a hand away from his face is not an immediate threat under any honest reading of that standard. There is also a civil rights dimension here. Under Section 1983 of the Civil Rights Act, any person acting under color of law who violates someone's constitutional rights can be held personally liable. Eflin was in uniform. He was acting as chief of police. The video, Williams' account, and witness statements form the foundation for a civil lawsuit that Williams and his attorneys would be well within their rights to pursue, and the Americans with Disabilities Act applies here too. Title II of the ADA requires law enforcement to make reasonable modifications when interacting with members of the public who have disabilities. Williams' paralysis was not hidden. He was visibly seated in a wheelchair. The decision to escalate physically against someone anatomically incapable of posing a conventional physical threat is exactly the kind of conduct that law is designed to address. By April 7th, 2026, the video was everywhere. Mayor Harris called for an independent review by an outside agency. He said appropriate action would follow. By April 8th, 2026, less than 48 hours after the video went viral, Bobby Eflin submitted his resignation letter. In it, he said it was best for him and his family to step away from service. He expressed gratitude for the opportunity and offered to assist with a smooth transition. No acknowledgement of what he did. No direct apology to Denarius Williams. Just a quiet exit. Wells Skaggs has since taken over as interim chief of police. I need to be direct with you about something because I think it is tempting to see a resignation and feel like justice happened. It did not. A resignation is not a conviction. It is not a criminal charge. It is not a civil settlement. And here's the part that should concern you in this country. There is a well-documented pattern of officers with histories of misconduct moving from one department to another. Researchers and advocates call it the wandering officer problem. The national systems designed to prevent it, including the National Decertification Index, are incomplete, voluntary in many states, and not consistently checked by hiring agencies. Without a criminal record or a formal disciplinary finding entered into law enforcement databases, nothing legally prevents Bobby Eflin from applying for a law enforcement position somewhere else tomorrow. He could show up as chief in another small city. That is not a hypothetical. That is a documented pattern across American policing. The independent investigation currently underway is therefore not a formality. It is the mechanism that either creates a permanent record or allows a clean exit. If investigators refer criminal charges to the prosecuting attorney and the evidence on that video suggests they should, it creates a record that follows Eflin. Without it, his resignation is just a door closing quietly behind him. The community of Osceola is not asking for anything complicated or unreasonable. They want the investigation to be real and thorough. They want criminal charges considered. They want the arrests of Stephanie Williams and her son reviewed for legitimacy. And they want to understand how a man became chief of police and 11 days later put his hands on a disabled man in front of their homes. Denarius Williams was shot in the back in 2013 and has lived in a wheelchair ever since. He has spent over a decade carrying the weight of a body that violence took from him, and on the night of April 6th, 2026, while worried about his wife and his son, he sat in that same chair and was struck across the face by the man the city of Osceola had just handed the most powerful law enforcement position in town. The neighbor who recorded that video made a choice to point her camera and keep it there. The community that gathered that night made a choice to be witnesses. And the reaction visible on that recording, the shock, the outrage, the voices rising, makes clear that what they saw did not look like law enforcement. It looked like a man with a badge abusing a man with no ability to defend himself. The question this case leaves open is not whether what happened was wrong. That part is settled. The question is whether the systems built to respond to it will actually do their job: a transparent investigation, criminal charges if the evidence warrants them, and a record that follows Bobby Eflin wherever he goes next. This channel will stay on it. When there is a development worth reporting, you will hear about it here. If this video found you, share it with someone who needs to see it. Subscribe if you have not already, and drop that comment below. Tell me where you are watching from, and tell me what you think accountability actually looks like in a case like this. I will see you in the next one.